In view of the earlier decision of this court on the subject matter, in the case of Malik Ostad, this writ petition is dismissed. But some corrections will get it by afternoon. The online will get it by afternoon.
Two for delivery of orders.
Item 2 also same, we are dismissing.
Item 3.
Item 3 is also dismissed. There are some corrections. We will make it online by afternoon. Okay.
Item 47 for pronouncement of judgment.
Yes.
May I please, your lord. Lord, in item 27, my lord, your lordship directed the election commission to file affidavit regarding, my lord, circumstances while, my lord, they issued English translation copy. They have submitted yesterday, my lord. It is not in the record. May I pray, my lord, the matter is taken on Wednesday, my lord.
Not Wednesday.
On
Next
2nd of
Monday.
September, my lord.
It goes to next Monday.
2nd of September, my lord.
We'll pick it up on Monday.
Lordship, lord.
As a representative, it is submitted by the learned counsel for the petitioner that an affidavit by the Election Commission of India has been filed need some time to go through it and respond. And that is the code. Matters is adjourned today, it's on 1/9.
Rescue, my lord, take the same, my lord.
What is the interim order?
No, my lord. Interim was there, my lord, it was not extended.
So then you have to file an interrogative application. If it is not extended, then it is gone. File an interrogative application. Consider it.
May I please, your lordship, my lord, I have a prayer in item 45, my lord. There is a, my lord, I am, my lord, in this case, my lord, lordship will kindly take it up at 2 p.m., my lord, if possible. This matter may kindly be upgraded, my lord. Item 45.
45.
Yes, my lord. Deeply.
May it please your lordship. Lordship, I beg to mention item 34 for upgradation, lordship. It may be taken up after motion matter, lordship. Because person is in detention, lordship.
You. Item number
34, lordship.
34. Okay, we'll upgrade it. We're not saying when, but we'll upgrade it.
May I please, the Lordship? Lordship, I'm seeking for an update for item 44 of today's daily list, Lordship.
44.
Lordship, the matter is of urgency as the petitioner is in transit camp, Lordship, and the matter have been released from the last two occasion, Lordship.
Okay, we'll see.
I object.
May please, your lordship, I beg to mention item number 6, lordship. Lordship may kindly adjourn the matter for the day. There was some emergency due to which my senior had to go out of station, lordship. Lordship may fix any short date for the matter.
Then made by that part. That's all. 3925. Yes. Next.
Lordship,
Yes, with the lordship. Lordship, with regard to item number 42, my lord. Well, I am praying for upgradation, my lord.
Forty-two.
May I please, lordship, I beg to mention item number 30, lordship. Finally, this matter may be upgraded, lordship.
30.
30, yes, sir.
I do.
Daily list item 1.
Yes, Mr. Sharma, you were required to file an affidavit. Look, you had, you had informed us that this document is fake. Page 11, page 12, in fact.
Oh, yes, lordship,
Have you filed an affidavit?
lordship. I can find it, lordship, because they could not find the death record, lordship.
Please tell us by when you can file.
Lordship, instruction is available, lordship.
Hmm?
Instruction is available, lordship.
No,
1
I
week,
will-
within 1 week, lordship, I think.
Okay, you tell a date. There's a calendar in front of you. That's the date. Of there's no representation from the petitioner. However, the all the respondents are represented. Like the learned standing counsel for the FT matter has wait for some more time for the affidavit to be filed by the Superintendent of Police Border, Kachar. List on
10th.
10 September 2025.
Item 2.
Main.
Yes.
Process by order dated, my lord, your lordship, 28/7/2025. Your lordship issued notice.
You
And
have to
today,
address the issue of maintainability because of the delay and latches.
my lord, now, my today pair for bail shall be considered, my lord, after receiving, my lord, the record of the tribunal, my lord. Okay, my lord. Till today, they did not file any affidavit, so, my lord, at least bail may be considered, my lord, otherwise,
Pardon me?
my lord, till today, there no affidavit has been
No,
filed.
correct, because this is a court's order,
My lord.
keeping the issue of maintainability open.
Yes,
So you have to address us on the issue of maintainability because there's a delay of 6 years.
Hmm.
How do you explain the delay?
my lord, I am already in my paragraph, my lord. Your lordship. Page, my lord. Para 18, page 14, my lord. May I read? Para 18, my lord. That the petitioner is a rustic person and studied up to 8th standard, having no basic knowledge, and consequence that she can oppose the higher judicial firm on time of the scrutiny of the opinion dated so and so, passed by the line tribunal below, while executing matter of her citizen. Moreover, her father was a cancer patient, and even after long treatment, he did not survive and died on 17/5/19. The whole case was monitored by the father of the petitioner. Due to death of the petitioner father on dated so and so, she became a helpless daughter, and she did not know about the father course of action about her.
No, but you
Yes.
see in
At
your,
the time also, COVID also, we are not mentioning.
no, that's
COVID
okay,
period
but
is
please
also
come
there.
to page 30,
My lord.
36. Paragraph 2, you are a married woman
Yes, my lord. Married
and
woman.
your husband is there
Husband is there,
residing
my
with
lord.
you.
My lord, he is also, my lord, some, I think, entire, my lord, file is in the entire communication with the advocate by her father, my lord. So I'm specific statements are there. And my lord, at this stage, my lord, at least one interim maybe protection may be given, my lord. And let them
The
already,
issue of maintainability, once you cross that hurdle, then we'll consider your prayers.
maintainability part, though, my lord, your lordship is mentioning, but till today, no any affidavit or objection is there. At least, my lord, that protection may I pray before lordship. And if I'm going to read the whole judgment or the report, my lord, opinion, we have seen that, my lord, I've seen that the headmaster school certificate is there, as headmaster evidence is there, everything is there, all, my lord, documents is there. So, my lord, regarding that issue, my lord, I pray for protection, my lord, at this stage, my lord. She has also a I-card, my lord, and she also, during, my lord, my lord, in date of birth 5/1/85, my lord, and section 3(1)A of the, my lord, provisions of the act, my lord. It also is, my lord, the citizen.
No, you see, that part the tribunal has discussed is incomplete. It has said that exhibit A, which is the identity card, voter ID card,
My lord,
there your linkage is with your husband,
my lord.
and that's not a pre-1971 document. Then, so
And-
far as exhibit B is concerned,
Father is there, grandfather is there, 71, before 71 is there,
but
And
how do you link
and my lord, if I,
your parent?
So, my lord,
And this
that,
exhibit B was not signed by the school inspector.
but certificate is there, and the headmaster also give the all record of the attendance register as well as record of the school, my lord. That is mentioned in the.
Where is the evidence of the headmaster?
Yes, my lord, your lordship. Page 42, my lord. Merit, my lord. Deposition witness number 3, the DWP. Name Sri Gita Bhuya, wife of so and so, occupation is headmistress, Jia ACC school, SC school. Today I have come to this court on receipt of this court's order. The school certificate produced before the aforementioned case by name of Mamtaz Begum, daughter of Abu Bakr Siddiq, so and so issued by the ex-headmaster of her school. It is true that signature is signed by the headmaster of her school. In the school certificate is true. Exhibit B1 is the said signature. Today, this honorable court, I have exhibited the registered khata, where the name of the opposite party is there. Exhibit H is the said registered khata, and serial number 620, the name of the opposite party as well as the date of birth. Father's name is mentioned herein, along with the signature of the headmaster of the school. In the Hazira attendance copy of 2000, her name is mentioned in rule number 9. Exhibit I is the page of the Hazira attendance copy where the opposite party name is mentioned. There was a signature of the assistant inspector of school in the certificate provided from your school in the name of Mamtaz Begum. Is the same signature of the assistant inspector of school present in the registered copy of 2000. There is no signature of assistant inspector of school in the registered copy. My lord, everything except that, my lord, and certificate page 47. Forty-seven is countersign is there by the inspector of schools, Sunitpur district circle. Page 47, my lord.
Krishna. Also heard for the ex-parte. Pursuant to order dated 28/7/2025, the whereby the issue of maintainability was kept open, the learned counsel for the petitioner has submitted that the our father used to take steps on behalf of the petitioner for the foreigners tribunal, and that our father died on 17/5/2019, and thereafter the opinion was rendered on 13/9/2019. And on his death, the petitioner could not take any steps and on being informed that he could approach the High Court against the opinion of the present petitioner has been filed. Learned Spanish for the FT matters has opposed the prayer for issuance of issuance of notice due to related challenge to the impugned opinion. However, in view of the explanation tendered, delay in approaching the court would not. delay in this case, would not dissuade the court to issue notice in the matter. Like, for the issue notice return over on return over on 29/10/2025. As the reports are already received, pursuant to order date 27/8/2025, no further steps is required to be taken. No, not issue notice, issue rule. Issue rule. Return over. That's what the reports are received. No steps are required to be taken. Next, this is the matter for hearing on 29/10/2025. The report that the learned counsel for the petitioner pays for bail which is posed by the learned standing counsel for the appeal. Considering the possession date, 10 days time to take bail out with 5,000 to the satisfaction of Superintendent of Police Border,
Sonitpur ma'am.
Sonitpur.
Yes.
10 days time to take bail.
Ma'am.
This for hearing on 29/10/2025.
Mark Sugle.
Item 3.
May I please, Lordship?
Yes.
Lordship, this is an ex-parte order, Lordship. And the main issue is the
But to
notice,
explain the delay.
Lordship.
the- the- the
Delay
question of
means,
maintainability,
Lordship, question of delay is not arising because the notice was not served to the petitioner. Lordship. Have a look at page 20, Lordship, process server report,
page
20, Lordship.
20.
Yes. May I read, Lordship?
Yes.
আর বিনীত নিবেদন এই যে নোটিছত উল্লেখিত গাঁওখন তাৰাবাৰী থানাৰ অন্তৰ্গত নহয় বৰ্তমান কাছমাৰা থানাৰ অন্তৰ্গত হয় সেয়েহে নোটিছখন জাৰি কৰিব নোৱাৰি মহামান্য আদালতলৈ ঘূৰাই দিয়া হ'ল নেক্সট লৰ্ডশ্বিপ উমেদ আলী ল'ৰা son of বাহাৰ আলী signature of উমেদ আলী মহাশয় মোতায়েন মতে আমি উক্ত ব্যক্তিজনৰ ঘৰত গৈ তেওঁৰ ল'ৰা উমেদ আলীক জাননীখনি জাৰি কৰা হ'ল আৰু জাননী কপি মহামান্য আদালতলৈ জমা দিয়া হ'ল and petitioner husband name is Nazu Mia Lordship. If Umed Ali is son of, and second issue is Lordship, petitioner has no any son, he has only 4 daughters. So how it possible?
Where is your statement to that effect?
Para 3 Lordship, page 3,
Yes.
merit Lordship.
The motion stage, this has to be allowed. You can back.
Yes, if it is murder, they.
This is the record. This is the record. As per the inquiry report, his son of wife of Naju. even at page 13, which is the notice of the writ petition.
Yes.
The notice is include the name of so-and-so husband Naju. So service on Umaid Ali, son of so-and-so.
Your lordship may remand it, my lord.
Your Mr.
A. Ali Lordship.
But Mr. A. Ali done a counsel for the petitioner. Also heard. not anything. The petitioner has referred this writ petition under Article 226 challenging the ex-parte order. Ex-parte opinion dated 9/4/2021 passed in FT case number 828 of 2017 by the learned member Fairness Tribunal number 7, Borpeta, Assam, declaring the petitioner as foreigner of the nation. The records of the trial court was called for by the order dated 37/2025, which have been received. Next paragraph. Looking at the grievance raised by the petitioner, the matter is taken up for disposal at the motion stage itself with the consent of the counsel for the respondents. The counsel for the petitioner has submitted that the proceeding had been initiated on a report by the electoral officer of Tenga 47 very 47 very a request was made to the SP Borpeta to make an inquiry as to whether Srimati Megjan, wife of Sri Nazu, is a foreigner under the IMDT Act 1983 oblique Foreigners Act 1947 and rules made thereunder. Foreigners Act 1946. On a reference being made to the Foreigners Tribunal thereafter, comma, notice was issued in FT case number 828 of 2017 to one Memjan, wife of Naju of village Sondonpur under police station Kasumara. The report of the process server, which is made available at Annexure 3, page 19 of the writ petition, which has been also seen to be available on record, shows that the notice was received by one Umaid Ali, son of Bahar Ali, on 19/3/2020. The opinion rendered by the learned tribunal at paragraph 2 records that at page 16 আছে মই ready underline কৰি থৈছো 8
The learned counsel for the petitioner submits that the petitioner is the wife of Naju and she does not have any son but has only 4 daughters out of the wedlock. Therefore, the question of her receiving the notice from the tribunal does not arise as it was handed over to one Umaid Ali, son of Bahar Ali, who is a stranger to her. Next paragraph. We have perused the TCR and verified that indeed the notice was served upon one Umaid Ali, son of Bahar Ali, Umaid Ali. The learned counsel for the FT matter has contended that the notice appears to have been properly served as Umaid Ali had claimed to be the son and also signed on the said notice. Next. Keeping in view the assertion of the petitioner that she is the wife of one Nessa Nazu, which is also reflected in the notice, and also keeping in view her assertion that she does not have any son. Service of notice upon the present petitioner cannot be said to be complete when the notice was served upon one Umaid Ali who claimed to be the son of Bahar Ali. We are therefore of the view that the petitioner had been denied an opportunity to effectively put forth her defense before the learned tribunal in FT case number 828 of 2017. Full stop. We therefore deem it fit to set aside the order dated, opinion dated 9/4/2021 passed by the learned member Foreigners Tribunal 7, Borpeta in FT 828 of 2017 and remand the matter back to the tribunal for rendering a fresh opinion by giving opportunity of defense to the writ petitioner. The writ petitioner shall appear before the tribunal on
Within 20 days.
within 20 days from today and submit her written statement before the tribunal. The petition stands allowed at the motion stage without issuance of notice on the respondents. The TCR be returned back to the trial court along with a copy of this order.
Obliged.
Item 4.
Please, your lordship. At least the petitioner before your lordship is against the impugned order dated 21/12/2018. Order
opinion.
page 24 and operative part is lordship 33, 32 to 35.
Your serial number is
In order, and serial number is 21. FT case number FTGD 484 of 2010, corresponding to SP inquiry number 84 of 2008,
21, serial 21,
serial number 20. In page number
At
29.
29.
Lordship, in this matter, the petitioner was detained by the border police on 27/5/2025. And after verifying this, all his documents, the border police released him and informing that the case has been registered for a foreigner. FT case has been registered against him. And after that, he come to know, and after that, the petitioner applied for the certified copy, and thereafter, the petitioner is before your lord.
But this order says that your notice was duly served.
Lordship, the notice is in page number 49 and 50 is the process server notice, Lordship. Where that was sent by the FT Gulaghat in 2012, that সন্মান পূৰ্বক জনাও যে উক্ত গোচৰ নম্বৰ ব্যক্তিক গাঁও পঞ্চায়ত সহ গাঁৱত বিচাৰি পোৱা নগল, মাননীয় আদালতত দ্বিতীয় তাৰিখৰ বাবে আবেদনৰ বাবে প্ৰাৰ্থনা জনালো। Thereafter, Lordship, Lordship, in page number 42, Lordship, in order page number 42, the case was transferred to the FT Foreigners Tribunal, Jorhat, by order dated 24/7/2018.
Yes.
In page number 42, the CR is received from transfer FT Gulaghat for disposal. They registered the same as FTGD 484 of 10. Issue notice to the opposite party number, opposite party fixed on 24/7. Lordship, in this after that, the FT Tribunal Jorhat has also issued the notice to the opposite party, and the notice is page number 55. Lordship, the process server notice is the page number 55, the vernacular part. The মহামান্য সন্মান সহকাৰে জনাও যে উক্ত বিদেশী ন্যায়াধিকৰণ জাননীত উল্লেখিত ব্যক্তিজনক আমি বিচাৰি যাওঁ, কিন্তু উক্ত স্থানত ব্যক্তিজনক বিচাৰি পোৱা নগল। সেয়েহে গাঁওবুঢ়া নটিচ বোৰ্ডত কপিটো লগাই জাৰি কৰা হ'ল আৰু মহামান্য আদালতত কপিটো পুনৰ বিচাৰৰ বাবে প্ৰেৰণ কৰা হ'ল। Lordship, in this matter, Inul Haq was this petitioner. The notice was served at the village of Mikir Bosti, whereas the petitioner is resided at the village of Islampur. So two different villages, adjacent villages. If the Lordship carries the notice, the Inul Haq, son of Muhammad Ainuddin, village Mikir Bosti.
Yeah.
And he is the resident of Islampur, Lordship. The Gaubura certificate is Lordship. Gaubura Lord certificate is the Lordship page number 79 and 80.
No, that can't be. You see, you have changed the address without notifying. Come to page 37.
Lordship. Lordship, page number 37.
In the form at you see column number 4.
Lordship, Mikir
Your
Bosti.
address is Mikir
Bosti.
Basti.
Mikir Bosti.
So therefore, after this, you have changed the residence.
Lordship, we have never changed, the petitioner has never changed the address, Lordship. Lordship, at the page number 85, his forefathers, the patta, that is the under the Giladhari, Moza Giladhari, that is the earlier district Sitsagar. That is, there is a landed property in the Giladhari, under the Giladhari Moza lot. In page number 85.
From where can we find that you ever told any of the authorities that you are a person from Islampur, Mikirbat? The notice was when that form 7 at
Lordship.
page 37
Lordship.
says that it is one Inul Haq,
Inul Haq.
son of Ainuddin from village Mikirbat.
Mikirbat.
Where does Islampur come in from now?
I am,
You are not the same person on this notice. Is that your case? No.
Yes. Lordship, I am not, I am the Inul Haq, I am not, my name is not recorded as a Inul Haq in any document, Lordship. I am Ainul Haq. And my father name is, there, the father name is Ainuddin. So after that, we the father name is same, Inul Haq. Ainuddin.
You see, you are inviting trouble for yourself. Now in the writ petition,
Lordship.
at the cost title at page 2, now you have introduced yourself as Ainul Haq, alias Inul Haq. Therefore, you can't result back and say that you are a different person.
I am,
Are you also Inul Haq?
no, Lord.
Then why the alias in the cost title?
Lordship, otherwise, when I was detained by the active border police, then the active border police informed me that the case is registered against me as a Inul Haq, the father of Ainul Haq, Ainuddin. So I am Ainul Haq and son of Ainuddin. So maybe the spelling.
Miss Verma, in this, at page 24, I think 50% of the cases we have already, it has come back to us.
Yes.
More than
they
50% has come.
Yes, Lordship. Court had directed for motor registration of these cases. Sir.
And all his documents show that he is of a different village.
Lordship, it is a very common thing for them to have 2, 3 names, Lordship.
he may deny that he's not I null or in null lordship, but
No.
it is his submission lordship.
So we understand, but ultimately, when we look at his documents, in all the documents, including the voters list and all everywhere,
Yes, lordship.
his projected address is seem to be correct.
Lordship, the first voters list is again a single name
Secondly,
voters
that is
list
one part.
of
The second part
other-
is, so that is one part. The second part is that it was served not at the house, but at the Gangura's notice board.
That is the second notice. If lordship comes to the opinion lordship, I've just gone through it. The opinion is on page 32 lordship. And at the very beginning, the member has very clearly stated about the notice part lordship. On receipt of the references in the aforesaid cases made by the competent authority as defined through into my predecessor tribunal, therefore registered the above noted cases, issued separate notices calling upon the opposite parties for above named to appear and also to file the respective WS. Meanwhile, these cases are transferred before this tribunal on the jurisdictional ground. However, on transfer of the cases, a fresh notice was issued to the said OPs, which was duly served as per so. That means they have received notice twice, lordship. Once the predecessor had
The
said,
address are same, you see, that recording at page, this paragraph 1
yes,
does
lordship.
not seem to be correct. Please come to page 29, serial number 21. This is the only address.
Present address.
That is the only address. In the
Okay.
reference also, it is the only address.
Yeah, in the reference also, there are no two addresses.
no
That-
two addresses.
Yes, I have also checked that, lordship.
Because in para number 2, it was also mentioned that there's two permanent present address and permanent address as to except the Golaghat district.
Lordship may examine this matter, call for the records, lordship.
No, you see, this third thing, please come to page 33,
Yes, lordship.
second paragraph, in the connection,
It
in
is-
this connection.
It is to be mentioned that services, lordship, reading this.
In this connection, second paragraph,
Yes,
it is to be mentioned that the service of notice on so and so 35G is as follows. Where the procedural adult member of a family is not found as a residence, a copy of notice shall be pasted in a conspicuous place of his or her residence. So he writes this and then service is wrong.
notice to.
And then again, in the same paragraph,
Yeah.
about the end of it, 6 lines below that, it says the notices are therefore
Duly served.
duly served as so and so.
But there's no denying the fact that the petitioner knew that there is a proceeding against him, lordship.
It's okay. And it means served in his address.
And this order was passed in the year 2018, lordship.
At page 33, the paragraph just below the one that we were reading, in all the aforesaid cases, notices were served by the process server on being identification of the last place of residence by the concerned house owner. There is nothing on record here to show that the house owner made that statement or something. Then again, in all the aforesaid cases, the house owners have admitted that the last residence of the said OP at their respective premises, but equally they have disclosed before the process server that the said OPs have left their place of abode. The process server's report does not say that.
It doesn't mention.
So he
So,
determines
lordship,
this.
the inquiry report, my submission would be the address he has given to the police, that is there in the inquiry report. Whether he was there or not there, whether he went there to work and he shifted after some days, that has never been informed to the police. He knows that there is an
That's
inquiry
okay.
against him.
there are
No, even that's okay. We admit it. We are not disputing what you are submitting. But is the finding at page 33 correct? A tribunal is not supposed to manufacture case. It would have recorded the due acceptance, we would have agreed to it. But now he's starting to manufacture. You see, when he takes up 20, 25 cases together, it's bound to happen.
Yes.
He does not have time to go through all the records. He is just presumed something which is not there, cooked up.
Paragraph 7 also, Lord.
Hmm?
Paragraph 7,
7
the opinion,
of the
opinion law.
opinion. Which page?
Page
Oh, actually,
11, page 11, Lordship.
Page 34. Page
34, Lordship.
one more. Well, we won't comment on this paragraph 7 because otherwise it would affect all the opinion. All the opinion.
Lordship, another thing, in case Lordship wishes to remand the matter back, Lordship, the voters list here, they are just of a single person. The father, mother's name is not there. Lordship may examine that also.
No,
Because
this
single
is a-
name
this is a
voter list,
defense- This is a defense which he will have to take in the tribunal.
null.
We can't expect that those things to be.
It may just make an observation that he has to
No.
submit
why-
complete
why-
voters list.
Why we should what you call start educating? We ourselves don't know many things.
Let him,
We ourselves
go-
don't know many things.
yes,
How can we
Lordship.
start lecturing? Mr.
SRA Nasir.
S.
RA Nasir.
R. Ahmed
Nasir.
Nasir, learned counsel for the petitioner. Also heard so and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely, Inul Haq, INUL, alias Ainul Haq. First is Ainul, AINUL, Ainul Haq, HAQUE, alias Inul, INUL, Inul Haq, has assailed a part of the common opinion dated 21/12/2018, passed by the learned member, Foreigners Tribunal Jorhat, insofar as it relates to the case at serial number 21, being case number FTG within bracket D, bracket close 484/2010, corresponding to SP's inquiry number 84/2008, page 29, in the case of State versus Inul Haq. Full stop. By the said common opinion, amongst others, the service of notice of the proceedings to the petitioner was accepted to be duly served under section 3, under order 3 within bracket 5 within bracket G of the foreigners within bracket tribunals, bracket close order, 1964. And the petitioner, amongst others, were declared to be foreigners who have illegally entered into the territory of India within bracket Assam after 25 in 1971 without any valid documents. Next para. The learned counsel for the petitioner has referred to the photocopy of the of the certified copy of the notice and service report regarding service of notice on the petitioner, which is annexed at annexure 4 to this writ petition. And it is submitted that that as per the process service report dated 19/6/2012, the proceeding could not be found to stop. The notice we have said, copy of notice that's also issued by the Foreigners Tribunal, Golaghat, in case number FTG within bracket D bracket closed 84/92. Full stop.
12,
Next.
12, 84/12.
84/12. Okay. 84/12. Next. It's posited that subsequently the said proceedings was transferred to the transferred for disposal before the learned member, Foreigners Tribunal, Jorhat, and the proceeding was re-registered as FTG within bracket D 484/10. To start by referring to the process service report. The next is annexure 5 to the writ petition. What is projected that it is stated that as per the process service report, the notice of the tribunal was attached to the notice board of the Gaungura. And accordingly, it was reported that the notice was served and returned to the learned tribunal. Next. Based on the process service report, the learned tribunal had discussed the service of notice at paragraph 3 of the impugned opinion, wherein it has been stated that it is stated, inter alia, that notice to the petitioner was pasted at the conspicuous place of their last place of residence, i.e., at the outer part of the house where they used to stay earlier on rental basis, because they could not be traced out at the given address, i.e. present address of the process server. It is also mentioned in the impugn opinion that the notices are duly witnessed by the owner of the house and a renowned person of the localities concerned. The learned tribunal has also referred to the provisions of Order 3 within bracket 5 within bracket small g of the foreigners within bracket tribunals bracket order from 1964, which mandates that the copy of the notice is required to be pasted in a conspicuous place of his or her residence, witnessed by one respectable person of the locality. Next. No such way, continues him. Accordingly, it appears that the finding of service, as recorded by the learned member of the Foreigners Tribunal, Jorhat, is contrary to the contents of the photocopy of the certified copy of the process service report, available at Annexure 5 to the writ petition. Next. Although the learned standing counsel for the FT matters has vehemently opposed the entertaining of the present writ petition on the ground that in the reference, the address of the petitioner is given as village Mikir Basti, MIKIREASTI, Merapani, under PS Merapani, district Golaghat. It is evident from the cost title of the present writ petition that after the inquiry was made, the petitioner had shifted his residence to village Islampur under PS Merapani, the district of Golaghat. Accordingly, it is submitted that as the change of address had happened without notifying it the border police, the ex-parte opinion rendered against the petitioner ought not to be lightly interfered with. Next. There is no dispute that the inquiry against the petitioner was made at village Mikir Basti, Merapani, under PS Merapani. And therefore, it is quite possible that the petitioner, after the inquiry, had left the said residence. Nonetheless, the process server ought to have served the process strictly in accordance with Order 3 within bracket 5 G, small g of the foreigners within bracket tribunal bracket act, order from 1964. Any deviance of the manner of service ought to have been by virtue of orders passed by the learned tribunal. Full stop. Next, in this case, had the learned member, foreigners tribunal, Jorat, referred to the contents of the process server's report and had justified the manner of service to be in accordance with Order 3 within bracket 5 within bracket small g of the foreigners within bracket tribunal order of 1954, it would have been another matter altogether. In this case, contrary to the contents of the process server's report, the learned tribunal contrary to the an inconsistent finding has been recorded by the learned member from a foreigners tribunal Jorat that the notices issued amongst others to the petitioner was displayed public pasted at the conspicuous place of his last place of residence, i.e. at the outer part of the house where they used to stay earlier on rental basis. Full stop. This being contrary to the photocopy of the certified copy of the process service report available on record. Next, resultantly, the notice cannot be accepted to have been duly served as per Order 3 within bracket 5 within bracket small g of the foreigners within bracket tribunal Order 1954. This, in the considered opinion of the court, has vitiated the ex parte opinion dated 21/12/2018, only in respect of the present petitioner, Ainul Haq, yes, Inul Haq, who is the proceedee at serial number 21 of the impugn, said impugn opinion. Next. Resultantly, at the motion stage and without issuance of notice on the respondent, the ex parte opinion, it is when so from correct. Is hereby set aside in respect of the petitioner, namely so and so, without affecting the said ex parte opinion insofar as other proceedings in the common opinion are concerned. Next paragraph. The petitioner, who is duly represented by his learned counsel, shall appear before the foreigners tribunal, Jorat, within a period of 20 days from the date of this order, and on his appearance, he shall file a written statement of defense. Next, in the event the petitioner does not appear before the said learned tribunal within the time at all, it would be open to the learned tribunal, part a separate and fresh opinion in accordance with law. Next paragraph. The petitioner shall produce a certified copy of the order before the said learned tribunal. Next, the registry shall communicate copy of this order by email to the learned foreigners tribunal, Jorat, at the following email address: Next, petitioner shall also produce a certified copy of his order before the superintendent of police. Yes, who is the superintendent of police in here? Superintendent of police border,
Golaghat.
Golaghat, to bring the order to the north of the center.
Deeply obliged.
Lordship has fixed a
20
date,
days from today,
20 days.
should we say you can communicate the order also?
Yes, sir. You can come.
We have asked him to produce a certified copy. We are communicating order through our registry by email. That will do, or you want an?
No,
through
Lordship,
registry?
to registry.
Lordship, may I pray one thing? Then in item number 14, Lordship, the similar matter, the petitioner is the wife of this present petitioner. So may I pray for the taken up now, Lordship, because as my wife is admitted in the hospital, so I have to, he is supposed to release today. So if Lordship is.
Item 51.
14, Lordship.
14.
1/4, Lordship.
Same opinion?
Same opinion, Lordship. I serial number 22, Lordship.
Facts may be different here. 14. Item 2B. Same. Let him take it. Same order. Similar order. He'll take it. Where is which page is the opinion?
Opinion is Lordship, item number, sorry, page number 97 from 93, and operative part is Lordship, 101 to 104.
93.
93, Lordship.
And your serial number is?
My serial number is 22, Lordship.
There is only change. Same opinion, serial number 22. Namely, Alsi Begum, ALSI, Alsi Begum.
My original name is Arpinara Begum.
And the writer name is Arpinara, ARFINARA, Arpinara Begum, alias Alsi Begum, ALSI, Alsi Begum. Where is the process server's report?
Report is Lordship, page number 84 to 87, Lordship, process server report. Last 19, page number 92, the process server report of the active tribunal Jorhat, sorry, 92 page number. Vernacular.
Here the Here the first service report is dated 19/6/2012. 19/6/2012. After that, there is a transfer, and the second notice. Second process service report is which page?
Second process server report is page 92, Lord.
Second process service report is dated 29/2018. Same order.
Second.
Deeply obliged, Lord.
Item 5.
Wait, please, Lordship. Lordship, this matter may pass. This matter may be passed over for a day, Lordship, because engaged counsel SDs have some difficulty today, Lordship. If possible, Lordship, matter may be taken up either on Monday or Wednesday, Lordship.
Wednesday.
Yes, deeply obliged.
The clear made by run based on 3/9/2025.
Item 7.
6 to maintain.
If may please, Lordship. Lordship, it is contested matter. Opinion pages is 29, Lordship. Opinion dated is 18/3/2025, Lordship.
Page?
Page 29, Lordship.
You're Mr. I. Chakma.
A.K. Hazam, Lordship.
A.K.
Hazam.
Hajam. Heard Mr. A.K. Hajam, counsel for the petitioner. Also heard counsel for the respondents. The present petition under Article 226 of the Constitution of India has been preferred, assailing an opinion dated 8/3/2025, page 29, by which the petitioner has been declared to be a foreigner of the post 25 March 1971 stream. Issue notice returnable 4 weeks. Since all the respondents are represented, extra copies within a period of 3 working days from today. Heard on the prayer of interim bail. Heard on the prayer for interim bail. The learned counsel for the FT matters has opposed such prayer. However, looking at the projection made in the writ petition, we are inclined to grant bail to the petitioner. Bail confirm. The petitioner shall appear before the Superintendent of Police, Border, Walpara. Please, the receipt of bail.
Ms. Verma,
Yes, Lord.
there's one thing we'll have to point out to you. I think there's a very uh, it appears to be incorrect approach. Please come to page 33 of this writ petition. Last line, the data containing in the chitta book that he brought with him exactly tallied with the above mentioned datas which he mentioned in his statement.
Hmm.
Now finding, on being cross-examined by the AGP, the witness has stated the book which is brought with him belongs to year 1992. The address of the patadars are neither mentioned in the Chitta book nor in Jamabandi book. This will not be there. The Chitta and Jamabandi are only made as per the dag and you see Chitta will be starts from a dag, and Pata will start from the Jamabandi will start from a Pata. They will only give the revenue village. And in the locational address is never there in this document. Subject to correction because things may change by now. My experience is 10 years back. Because it never contains. So therefore, the question is wrong and the answer which came was equally incorrect because it was a wrong question put.
At the time of hearing, lordship may make.
I will not remember.
No, lordship, we have marked it, lordship.
Because this we will not remember, but the rejection of this Ramadi and I may also say that perhaps some section of the lawyers, they do not know to interpret the land records. That is the difficulty. The documents are exhibited and they don't know how to handle the exhibited documents.
Even I'm very bad with land documents, lordship.
No, you see, we appreciate what you said, but you don't do that. You don't go around without knowing. You are not going around exhibiting the land documents. Once you don't know, you are not touching that. That subject matter you are not touching.
Yes.
So that is also good. You see, that is to be appreciated because if I have difficulty in addressing a particular matter as a lawyer, and I am not taking up that matter, it's a good service to the litigants. I would appreciate that, in fact. The non-appreciation comes only when you handle the document and you don't know how to handle it. That is one part. The second part is art of cross-examination. Art of cross-examination, you must know what exactly would come out from the mouth of the witness.
Yes, Lord.
If without preparation somebody asks a question, then he has done his job. We'll take a short break and come back.
Yes, Lord. Yes, sir. মই এটাও কপি নাৰাখো চব লৈছো দিছো Sir, Damien, এই 37 টো চাই দিয়া না
37.
নোট কৰিব দিয়া না নটো আছে আমার কাছে নটো আছে দাদা আছে দি দিন এইটো আছে আপনারটা আছে छुट्टी नहीं होने दे रहे Oh my God. अच्छे नई नई शक्ल देखने को मिल रही है नई नई कहाँ पे थे फिर
मेरे चैम्बर में
बात
मेरा अपना बहुत
और चढ़ जाओ वहां जाके आप।
जितना काम
अभी मैं जा रही हूँ।
है
Okay. मेरे को काम है नीता हमारे
अभी हाँ तुम जा रहे हो वो रहेगा काम पर
सिविलर अच्छे
तो राइट हो जाएगा। रेफरेंस है ना बहुत सारे इसका एक का रेफरेंस है
मेरा ना घर पे अकेले कर देना भाई यहाँ पे मत करना
कुछ भी
ठीक है
कल आपने जो स्टोरी लगाया था अच्छा था
अच्छा था
मीनिंगफुल था
नहीं
मतलब मैच हो रहा था।
मैं आज जो लगाए वो देखो इंदिरा जयसिंह
आपने देखा
question
मैंने क्वेश्चन का
हाँ वेरी नाइस आई लाइक दैट
उन्होंने तो मतलब जो हमारे चीफ जस्टिस थे उन्होंने तो होने वाली स्टिल ही गॉट अपॉइंटेड ना टुडे आज तो उनका ओथ सेरेमनी होता है
some voices do matter
उतने देख
अभी दुर्गा पूजा में एक बिरयानी पार्टी होनी चाहिए, कोई इस बार तो तुम डिच कर दे।
नहीं नहीं करेक्ट
नहीं।
ये महीने बहुत busy था हमारा भी दीदी कल बोल रही दीदी बोल रही ये एक दिन बेटा तो क्या
हाँ, ऐसे करके मेरा भी दांत का प्रॉब्लम चल रहा था ना, इसीलिए
मैं आपके बहुत busy
मेरा भी काफी वो था प्राइवेट मैं जब भी सोचती था काम नहीं करूँगी, फिर कुछ नए चीज आ जाते हैं।
हमारे साथ ऐसे होता है मैम जो बोलते हैं हमको तो पता छुट्टी ले लो फिर 2 घंटे बाद बोलेगी कि आज तो लेट होगा खाना बनाने को हम बोलते मैम आप जब भी बोलते हो छुट्टी है यार उसी दिन काम होता
यार अच्छा लगता है, नाइस होता है। मैं तो सोची थी पहले रिश्ता अपनी सबसे ऑफिस नहीं करूँगी, पर मैं तो काफी नौकरी सीखती
अब तो हम भी बात कर रहे
और मैं मेरा क्लियर चल रहा था कि ये पपेटी इसके इन तो है
देखना पड़ेगा
लेकिन तू
देखना पड़ेगा
कोई बात नहीं पता पूरा
उसकी बात करेगा पता है मैं आपको पटना पटना एयरपोर्ट है ना
मैं क्या बोलूंगी ब्रदर जैसे ही बोल दिया अभी तक
वो तो पटना एयरपोर्ट से एक दिव्य बात करता है हाईकोर्ट वहां जाने से रोक सकते
दोष बना रहेगा काम करते हुए।
तो टाइम चल रहा था
ऑफिस कमिश्नर पुलिस को ऑफिस नहीं
आप यहीं पे रहोगे अभी
भी हूँ यहाँ पे आज कल भी मैं
नहीं
समाचार
मतलब यहीं पे
बात करने
आपको फोन
Four to three. Này, kẹp lên đâu, cái đơn rút ra. Đơn độc.
Item 8.
Yes, Mr. Raju.
Wait, please, your lordship. Lordship. Opinion dated is 28/3/2025, lordship, page 30, lordship.
Page
30, lordship.
Administrator AK Bachao. FT details to page 30. Opinion 28/3/2025. If you notice returnable 4 weeks. Please call for TCR. Petitioner has paid for interim bail, which is opposed by the London Council. However, in view of the projection made, we are inclined to grant bail. Shall appear before petitioner
SP border Golpara, lordship.
SP border Gwalpara.
Golpara.
Please stop that. 4 weeks on receipt of
9.
Deeply obliged.
No, please, the lordships. Lordships, the petitioner is presently in the holding center, lordship. He was arrested and arrested on 28/5/2025. The fact of the case is that the petitioner, lordship, impugn order is at page 19, lordship, starting from page 19 to 22, lordship. May I submit some facts leading to the case, lordship? From 28/6/2022 till 17/7/2023, he appeared and took some step. Thereafter, he remained absent without step, lordship, and that resulted in passing of the order. And thereafter, he was arrested and detained, lordship. The impugn order was passed on.
You have
Lordship,
to wait for some time for bail.
lordship, lordship,
Let us call for the record.
lordship,
because You have missed it by about a month.
lordship. Some short please prior to Puja, if possible, lord.
It's okay.
I'm not pressing for bail at this stage, lordship. I'm in fault. I'm in fault.
It's okay. Okay, we'll get it by email.
Lordship.
Heard. Order to provoke page 19. Ex-parte order dated 9/7/2024. Issue notice when I put so. Call for TCR. Therefore, bail will be considered on receipt of TCR. However, in the meantime, if the petitioner has been detained, he will not be deported without order. Please stop that.
Obliged, lordship. Lordship. 15, lordship. 15 September. Obliged, lord.
Ten.
Please, lordship. Lordship, page 31 is the opinion, lordship. 31, lordship. Opinion dated is 28/2/2025, lordship.
Third AK Raja. Response is zero. Impugned opinion at page 31. Opinion dated 28 to 2025. Notice steps within copies within 3 days, 3 working days. Call for the TCR. Then a council has paid for interim bail, which is opposed by the respondents. However, in view of the projection made in the writ petition, we are inclined to grant bail. Petitioners appear before the superintendent of police,
Gwalpara.
Gwalpara. Which chapter is it?
Next. Yeah.
W.
There is no.
Item 11.
May it please your lordship. My lord, impugned order is at page 56. 56 lordship. Impugned order dated 5/12/2018 lordship.
It give the issue of maintainability open and issue notice.
Yes, lordship, and I have explained, it's in paragraph 55, page number 49. It starts from page number 49 and
We
it's
will-
at, and
Take
it's,
a call on the next date.
yes, lord.
Fix a
And she is in detention, lordship, from 2012/2024.
20.
12/2024. And here we have brought in more documents, lordship, where if it would have been exhibited before the learned tribunal,
Next date.
yes, lordship.
Heard Ms. D. Ghosh, also had respondents. Challenge in this writ petition under Article 26 against the opinion dated 5/12/2018, page 56. Keeping the issue of maintainability open, issue notice 4 weeks, extra copies 3 days. Email call for TCR with email. Prayer for interim will be considered on the next returnable date. However, since the petitioner has been detained on 20/12/2024, it cannot be deported if not already deported without further.
Lordship, I'll humbly pray for a date, lordship.
And list on. The certified copy of this order be produced before the in charge.
She is in the transit camp, Matia, lordship.
Of transit के Matia, not a particle. Transit के Matia. List on.
Can it be 16, Lordship? 15, I'll be out of station for a matter. Can it be 16 or whatever is convenient for Lordship? Yes, Lordship. Thank you. Yes, deeply applied.
Item 12.
They will, after sometimes, Lordship, senior is another.
Your name?
Islam.
A. Islam. Mr. A. Islam. Respondent for return. The petitioner has received the impugned opinion dated 18/2/2025, page 85 out of issue notice, extra copies within 3 working days. All for the TCR. The counsel for the petitioner has paid for interim bail, which is opposed by the Illinois counsel for the FP matters. However, in view of the projection made, we are inclined to grant bail. The petitioner shall appear before the SP.
Gwalpara, Lordship.
SP border Gwalpara.
Obvious.
Item 13.
May please your lordship, this is contested matter, lordship. The impugned order is that page 79, lordship. This is an order of 22/2024, lordship. February 2024, lordship. This is from Nagaon, lordship. No. May I pray for some protection, lordship? This is a lady law. 22. Lordship, lordship.
Mr.
That is it.
Hussain, petitioner assails the opinion dated 22/2/2024, passed at page 74, page 74. Sorry, 79,
79.
page 79. Issue notice. Returnable 4 weeks. Issue notice returnable 15/9, right? 15/9 to extra copies within 3 working days. Therefore, interim relief will be considered on the receipt of trial court record. Call for the trial court record by email to list on 15/9.
Lordship, obliged.
In the interim, if the petitioner is apprehended, she would not be deported without further orders.
Deeply obliged, lordship.
Item 13, Lordship.
13.
Yes, page Yes, Lord. आगे लिखी थी बस पुलिसों की लिखी था लेफ्टिनेंट पास इंस्पेक्टर 98 log में जाओ बैठे कॉलम से लिखा पाहरी जगह तो कॉपी तो रिसाइकल को लेते
Item 15.
May I please, Lords? But it may kindly come to page 75. The petitioner was released on the stand of this judgment, Supreme Court of India. Part 76, Melo. Insofar as the release of detainees who have served long period of detention in the detention center, awaiting their deportation is concerned, we are of the view that detainees who have completed more than 3 years may be released subject to the following conditions.
I said during COVID
No, my lord. Yes, my lord.
In the morning, we have dismissed 3 such writ petitions. This will follow the same.
So, my lord, thereafter, the petitioner directed to appear before the local PS. He has released, my lord. Thereafter, he
Those things will not help you.
regularly appeared before the
Those
PS.
things will not help you.
Lordship
The purpose
2017
of
order
your
stands.
expulsion, the state can take you into custody.
My lord, only submission till deportation. The petitioner may be released.
Even
Today, 3 matters have been
Yes.
even
rejected.
Police
Yeah.
custody.
But Lordship 2017 order has not been challenged. He went to Supreme Court, it has been dismissed.
No
Lordship.
challenge was made, it was dismissed. Page 21.
Yes,
Petition
Lordship.
2018, it was challenged,
Yes.
dismissed, but thereafter, nothing happened.
Petition dismissed, my lord. Thereafter, Supreme Court
Dismissed.
that also dismissed, my lord.
Review also.
Yes, my lord. So, my lord, simple prayer, my lord. Till deportation,
But they have
on
exhausted.
the extent
all
of
remedies,
Supreme Court
Lordship.
judgment, the petitioner may be released.
But he has to be deported from somewhere. Till that point, he has to stay somewhere where
No, my lord, some days ago, the wave was come.
Sorry, we have considered your prayer, but it will be rejected. Pass orders in the chambers, we will get it tomorrow. He was taken into custody when?
25, 2025.
5.
Earlier, I was in custody more than 3 years.
From when to when?
That is my lord.
For 2022.
Review also different.
You were initially arrested when?
For a long time. Page 10, my lord, of my petition. Page 10, para 13, my lord. Arrested 15/2 to 2017, my lord.
Yes, notice. Okay, we'll pass orders in the chamber. We'll get it tomorrow. It may not be released today. Or not even tomorrow, it will be Monday.
Monday, Lord.
Your name?
Okay, Islam, my lord.
Islam.
Item 16.
Was
May it pleases your lordship. My lord, impugn order is at page 30. Order dated 29/1/2025. It's a contested matter.
We get into. Usually we're gonna box that.
We have heard you or we have heard her?
There is lordship.
Yes, you have the courage. You have the courage.
This is my first time.
We didn't hear you.
Sorry, lordship.
We did not hear what you said.
The lordship, this is my first time in this court.
You have the courage or you don't have the courage.
Yes, you have prepared the notes. You are-
Oh, no, I can't.
You argue, you have prepared the. Okay.
No.
No.
Okay, be prepared. We pick you up from anywhere. Ask you to address, correct?
He only prepared the notes. He only prepared the brief. Where is the, everything she has prepared. Ask him.
Go to good gym. Get some courage. Okay. Your name?
Lordship Prerna Das.
You are there in the
He is not there in the wakalat lordship.
then we'll record your name. Heard two people. You cannot also heard the respondent. By this under Article 53. Here, page 30. The opinion dated 29/1/2025. Issue notice. Return to full weeks. Extra copies within 3 working days. Call for the PCR. And the council has paid for interim bail of the petitioner, which is proposed by the council appearing for the 50 matters. However, in view of the protection made in the petition, we are inclined to grant bail. So petitioner will appear.
Lordship, we had made here, both the the court is in, tribunal is in Bojali, her residential address is Baksa district. So both the SP borders are party.
will
So my learned friend might say
but when
whichever
we
will
record-
be.
Let both the SPs be directed, lordship, wherever the records are. It will
Yes.
facilitate lordship.
Petitioner will appear before the Superintendent of Police Border, Bojali,
and also Superintendent of Police Border Baksa. End of video. Receipt of
Page 30, with the opinion. The IMT case is written here. In
Deep read.
17.
Page 44 is the end of that is 21, 3, 2022. Page 44. 44.
Daदा, Daदा, copy will have no.
You'll have to wait for some time for bail.
But Mr. Kriya. I also heard the respondents by preparing this description. Article 226 of the Constitution of India, the opinion dated 21/3/2022, page 44. You notice returning 4 weeks. Extra copies which are for the respondent within 3 working days. For that area, I believe prayer for bail will be considered on the receipt of PCR. However, in the meantime, if the petitioner is apprehended, he would not be deported without further orders from the court. The petitioner will
Common office.
cause production of certified copy of the court before the Superintendent of Police Border Rural within a period of 20 days.
He will, then he will take it into custody, my lord.
He will be taken into custody, he will not be deported.
And Mr. Ahmed,
My lord.
you have saved some money, and in the process, you are causing us some trouble. Come to
Well-
page 3, paragraph 6.
Hello, paragraph.
Paragraph, serial number 6. I was trying to find out in the morning where Kamrup rural district is. In the map which I have in my chamber, you don't have Kamrup rural.
Now Kamru.
Now Kamrup.
Earlier it was,
And secondly, you don't, you have saved money in not typing Amingaon.
You have some time now, now.
You have saved a lot of money.
my. I'm sorry, my lord.
Kamrup rural. I mean,
Item
Hello,
18.
Okay, my.
সেটু আমি রাখি মাকে একটা কপি ঠিক করে দিব হ্যাঁ Lordship, item 18 is one of those analogous common order passed in ex-parte orders. So Lordship had same member, same tribunal, Golaghat Lordship. So Lordship can pass the same order, Lordship.
Which page is that opinion? Oh, page 66.
Item 14 and thing was same. 4 and 14. 18. Common exam no size it is what. 71 of the.
In the impugned order, where is your name? What serial number?
Page number 66.
Where is your name?
F.A.
Serial
Ahmed.
number?
Okay.
Your name is at which
Second.
serial number on page 66?
Yes.
We are reading now. It doesn't help us. At 2 o'clock, be prepared. We are asking you one question, you can't reply. At 2 o'clock,
Lordship, I can help Lordship. 71. Page 71, Lordship.
You don't need it.
18. Serial 18, Lordship.
That is Jopikul
Yeah, it is Elias,
Alliance.
Tafikul, Jofikal.
with your expressions, we understand we have put you a very difficult question, very hard question. Not out of syllabus. Before you, we have taken it, Pratik. Will be same order. Uh, The date petitioner's name is at, is take from the cost title, so and so, alias so and so. And in the opinion, it starts from page 66. And it is a common order. The petitioner's case it as page 70, serial number 18. As per, in one paragraph, we have said about the service report, there it will be that as per the service report appearing at annexure K within bracket 1 of the writ petition. The notice could not be served at the as the at the given address. And the notice was served at the Kambura's notice board.
I think 29.
And the service was returned.
20.
Rest will be same. Only this much is the difference. Same. Your name?
F.A. Ahmed.
F.A. Ahmed. Petition is allowed. But Ms. Verma,
Yes,
you're putting
Lordship.
it as a very, my esteemed brother has asked, you are putting us in a very difficult situation.
Like,
Because in the first line, we'll have to write, not heard the learned counsel for the petitioner.
no, Lordship, I was trying to expedite because so many matters.
No, we understand.
Lordship,
but-
I small submission, Lordship. In one of the orders, Lordship can ask us to find out if all these ex-parte orders have been.
No, because that will lead to a different
Lordship,
connotation.
we need to find out, Lordship.
No, we understand, but
Just
If you-
one line, Lordship.
No, if you can,
Work on the other.
we can first, you see, there is a difficulty. The difficulty is that the court cannot, once you see, you are relying on the case of Bikartan Das. Now, can we of our own, in exercise of statutory jurisdiction, ask you to make an inquiry? Because this could have been done in the other bench. The foreigners bench which we are the taking up, their
Monitoring.
monitoring bench. Perhaps there we can
But
pass
like,
orders.
The time that bench
No, now it
has
will come up.
has a meeting, so many issues are forgotten, Lordship.
No,
I think.
that will be now regularly being, we have requested to hold it regularly, every month. So,
Lordship will make a note of this. We need to bring up these issues, Lordship.
oh, yes, but perhaps an extra remark in this order would not be
Lordship,
well
but
appreciated.
it is we have written, I will try to find it out.
Yes.
myself.
We can only say, in this order, we can only make a note that this is the third matter today where
Yes. This common, I'm sure more, because see, Lordship, these are ex-parte orders. So many days, nobody has come now because the deportation has started, Lordship. They are very well aware that there is a proceeding.
Correct.
Now they're rushing to court just to get that order not to be deported. Now they want the matters to be remanded back. It is not that the petitioners are not aware of this.
it's okay. At the last part, you can say that this is
Item 4, 14, and this was
item
18.
12 and 13. You can say that this is just before we end, we say we are inclined to make an observation that in respect of the same common opinion dated so and so, this is the third matter which has been taken up today, being the others being WPC 4920 of 2025. You give a dash. Mohammed Habibur Rahman alias. No, not this one.
4, 14,
I have
was Ainul Lordship.
4.
Item 4.
Item 4. Item 4. That is WPC 4857 of 2025. Give a dash. Ainul Haq alias Inul Haq versus Union of India and others. And item number 14.
1, 4.
WPC 4923 of 2025. Arfi Nara Begum alias Alsi Begum versus Union of India and others. And in view of the incorrect incorrect appreciation of the service report, both the writ petitions had to be allowed by remanding the matter for a fresh opinion. Just make that so. Okay. Okay, we have taken it up.
My lord, item 17, and that may be fixed, my lord. Otherwise, if I produce the certificate, I will return, it will within the
Pardon me,
item 17.
17, yes.
That may be fixed, my lord.
You want a date? Okay.
15-9, 15-9.
Okay.
Item 19.
May I please a Lordship, Milord? Given order at page 60, Milord, 60, annexure 10, Milord. This is a contested matter, Milord, and the final order was rendered on 11th of
It will be enough.
July, Milord, 2025, Milord.
Item
60.
19 is there.
Page number
Page number 60, Milord, 60.
60.
Yes, Milord, annexure 10, Milord. And outside, Milord. Praying for Milord interim protection, Milord.
No, it was in.
Yeah.
It is separate. review to file for it, 70, that petition notice of it. Review to calculate.
Before SP order, Mori government. Deeply. Yes, Miller, lot of difficulties are there, Miller. We have seen Miller. But from the record itself and yes, Miller. And the WS Miller, it connects somewhere. But right.
Item 20.
Deeply.
Ex-parte order, impugn order is page 21. 21.
Yeah. Lordship, here issue of maintainability may be kept open, Lordship. Notice served, Lordship did not appear, now taking a new view. Yes, Lordship. Yes, Lordship. Okay. Page 22 instructions. Yes, Lordship. That means he has been absconding, Lordship. Also returned. Was recalled for. Why? From the estimation from the member. Yeah, no.
If a process is issued, it must be accepted to be duly served. But here, this process was recalled. Once the process is recalled, there cannot be a service. Please read it again. If it has conveys a different meaning, page 23, last 4 lines,
The warrant issued,
warrant of arrest.
warrant of arrest issued against the proceedee, also returned unexecuted. As such, all pending process, whatever being pending for execution was recalled for. The case thereafter decided to be proceeded ex parte fixing on 18/2/2020.
No. Here, you see, that's why we are showing you the first part. In the first part, at page 21, page 21, paragraph 2, the petitioner appeared before the tribunal, asked for time. Correct?
Yes, Lordship.
Then we have a judgment saying, from our court, saying that once a process is served, there is no requirement of issuing a fresh process.
Fresh notice.
Now, whatever be that, but now the case is again fixed at this paragraph 2, in the middle part. It was fixed again for appearance. And then many chances were given. And paragraph sorry, page 22, fourth paragraph, warrant was issued. And what is your explanation, Mr. Ahmed? For not,
Yes, my lord. Para 3, my lord.
hmm?
Paragraph 3 and 4, my lord.
Paragraph 3 and 4.
Three mainly, my lord. 4 is the subsequent part, my lord. Start from 2025, my lord. Para 9 also, my lord. Para 9, page 12. Yeah.
The order sheet,
Order state, my lord. I am not an part, my lord. I have
okay, we'll take up the matter, only one, we'll take up the matter at 2. Because you are not satisfied with your explanation of the.
para 9
the-
also, my lord.
Paragraph 9 we have seen.
At 2 p.m. my lord.
At 2. You're not satisfied.
Later.
কি কলে
হেৰি আছিলে 4 আৰু 14ত
Probably flat, yeah. But actually 32, 37.
That is paragraph 4. After going through the case record, the state government returned him. আমরা লোক আনিব মই কেনেকে আনিম আপনার লোক ডকুমেন্ট ঘৰত আছে এতিয়া আকৌ ধৰিব
But Petitioner A.M. Ahmed, learned counsel for the petitioner, as well as so and so for the respondent. Next. Page 21. Ex-parte order dated 27, ex-parte opinion dated 27/2/2020. Passed by so and so in case number so and so. SP inquiry number so and so. Petitioner was declared to be a foreigner post 25 in 1971 state. Keeping the issue of maintainability open on ground of delay and latches in appearing before the foreigners tribunal and consequent delay in assailing the said opinion. I should notice returnable on in 4 weeks. Extra copies within 2 days, call for the relevant record from the concerned tribunal. Email at the following address.
Okay.
Prayer for bail shall be considered on receipt of records. However, in the meantime, if the petitioner, namely so and so, is apprehended, he shall not be deported out of the country without order of the court. This after issue notice to say we also take notice of the observations made by the learned foreigners, the learned member from a foreigners tribal Jorhat at subparagraph 10 of paragraph 3 of the impugned opinion, wherein the learned tribunal has made the following observation. Page 23, blue pencil mark. It would be appropriate if the concerned authorities in the home and political, home home and political B. Home and political B. Home and political B. Home and political B department response as to whether the said procedure adopted by the learned tribunal is in accordance with law. Page 23. Next list of 4 weeks are receipt of records. Just say that the petition shall cause production of a certified copy of the order before the. You were arrested when?
He was arrested on 25/5/2025.
25.
5/2025.
As the petitioner is prepared to be
Paragraph.
arrested and kept at the holding area Where is there?
Right now, he is in his house, my lord.
Hmm?
A detention center at Gwalpara, my lord. Initially, Gwalpara, my lord, subsequently pushed back, my lord. State government returned him back, my lord.
Now he's where now?
In his residence, my lord. Residence, my lord.
In his residence?
Is that
Yes.
lordship?
Okay.
Konmon buji napao. Ahiste hite jano.
The petitioner cause production of a certified copy of the order to the Superintendent of Police, order, which place? Order Golaghat, bring the order to the notice of the said authority.
Obliged.
Item 21.
May it please your lordship, Shakali pass over the matter for the day, your lordship.
Yes, no. Part of the day, straight forward, I'll pass to the petition.
Obliged, lordship.
Just a moment, we'll take it up on third. So Monday, we have many matters.
Lordship.
It's on the 9/2025.
Item 22.
Page 24, orders of February 24th. The orders of 2025, February 2020.
Passed by so and so in FT case number one, police reference D case number one. Taken the petition to be. Order post 25/3/1971. Notice preparable in 4 weeks. Extra copy within 2 days for the record. The prayer for bail is opposed by the landed standing cause for the FT matter. Actually, the 10 days time to take bail or rupees 5,000 to the satisfaction of
SP Dhubri.
the Superintendent of Police border,
Dhubri.
Dhubri.
Much obliged.
23.
Why?
My lord, lordship infusion order is page 76, my lord. Page 76,
Opinion
my lord.
page
76, my lord.
76.
6. That order date, my 12/12/2022, my lord.
22.
Lord.
Okay, you have to wait for some time for bail.
Okay.
Mr. A. Mubarak, counsel for the petitioner. Responded for the opinion dated page
76.
76, dated 12/12/2022, passed by so and so in FT case number so and so, police reference FT case number so and so. Taken to a foreign of 1971. Notice return of call for the record. Extra copies is included, call for the record by the following email address with the tribunal. Here for bail shall be considered on receipt of record. In the meanwhile, if the petitioner, namely Wahida Begum, is Musamad, MUS, Wahida Begum is taken into custody. It shall not be deported out of the country without order of the court. Next one, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police Border Nogam. Bring the order to the notice of the said authority. It's not proposed on receipt of record.
That's
24.
Please, page 87.
87.
3924 order that
Okay. Your name?
M. Rahman.
Pardon me?
M. Rahman.
M. Rahman, respond for there. Page 87, opinion dated 3/9/2024, passed by so and so. FT case number so, police case number 6. They declaring the petitioner to be a foreigner of post 25/3/1930. Notice returnable in 4 weeks. Extra copies is included. Here for bail is opposed by the learned standing counsel for the FT matters. Considering the protector. 10 days time, make bail out rupees 5,000 to the satisfaction of the senior superintendent of. No, this is senior superintendent. Now it will be deputy commissioner of police. No, your nomenclature is wrong, I think. Please.
Six
Uh,
is wrong.
Page
no?
87, it is referenced by the senior superintendent of police, border. Now it's to be deputy commissioner of police, but in the cost title,
Cross title.
it is superintendent of police. Barpeta.
Yes, that is also wrong, and senior superintendent, he has not mentioned senior lordship.
No, no. If he's in Guwahati, he'll be senior. Otherwise, in Barpeta, there is no senior superintendent.
No, not in Barpeta. It would be,
You find out which is correct.
Barpeta to part of senior superintendent.
How does Barpeta come in?
Last पे करते हैं। London Borali, Kamrup, Metro. DCP.
It will be district.
Lordship, it would be DCP because if the tribunal is in Kamrup Metro Lordship,
No, no. I'm going by page 87.
87.
87 reference is made by superintendent of police, senior superintendent of police, city Guwahati. And therefore, Guwahati tribunal is taking it up.
Yes.
His residence in page 2 is at Barpeta, but that will not vest superintendent of police Barpeta to give bail.
He will get bail here, Lordship, because the reference is from here.
You take a call, ask someone. You take it up after some time. Ask somebody.
Bail here till 48 to 10.
Yes, item 48.
May I please your lordship? Page 24, madam.
Page
24.
24.
The order is of 5/9/2024. Within 1 year.
DK Agarwala, to the cause of the petitioner. Respondents are there. Page 24. Opinion dated 5/9/2024, passed by so and so in FP case number so and so, IMDT case number. Petitioner to be a pardon of post 25 to 1971. Notice return with extra copies with proof or for the record. The prayer for bail is opposed by the learned standing counsel for the FP matter. Continuing prosecution, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of police border,
Barpeta.
Barpeta. Okay. This part focused.
My chocolate.
Upgraded item 30.
Yes.
Your lordship. Lordship, impin order is lordship at page 19 now. Operative part started from 21 lordship.
How do you explain the delay of 5 years to challenge the opinion?
Lordship, I have explained in my petition lordship, at
Paragraph
19 lordship, at page 14 lordship. He was met an accident lordship with a tractor lordship. Page 14 lordship, para 19 lordship.
I don't know about the present times, but when I was there, anybody suffering a accident was a pampered child. If and there was any motor accident, the victim would be a pampered child. Lawyers will come home, take their signature, do MSCT cases, given money for treatment, very pampered.
Lordship, actually, Lordship, due to
We don't
poverty
have-
also, Lordship, his
No,
Lordship.
we understand, but you've not given any details of what happened, which accident, what case number. Things have changed now. I'm asking the bar. Victims are no longer pampered. They've not given details. 2020, we are very difficult to condone the delay. And what is the best document you have to connect you to your projected parents?
So first of all, in this case, Lordship, this order operative part is started as page 21, Lordship.
Yes.
In this case, Lordship, reference was not completed, Lordship. Without basing the reference, Lordship, the proceeding initiated, Lordship.
Without reference.
Lordship, in the record, Lordship, also, Lordship, it is reveals, Lordship, this part, Lordship. And Lordship, may,
Oh, this is an ERO reference. We have dealt with it in many of our orders. This is not a reference by the police. This is a reference made by the electoral registration officer. They just created, at the time of revision of rolls, that is what is happening in Bihar, which happened in Assam many times. It's a extensive revision of rolls. And the electoral registration officer has a doubt about the citizenship of a particular person, and a reference is made. We have not come across any decision which says that even an ERO will have to do the appropriate investigation. ERO may be anyone. He may be a school teacher. He may be a grade 3 officer in any grade 2 officer in any establishment. They are taken up for election duty.
but Lordship, his knowledge, Lordship, with his knowledge, Lordship, he stated in his record, Lordship, birthplace, Lordship, at Morisha Kandi, Lordship.
No, you see, we'll tell you something. It's an electoral roll revision. Perhaps your name came for the first time in that electoral roll, and you were not of the immediate voting age. You are not 21 years or 22 years or 25 years. So therefore, you are flagged by saying that how did your name enter here? And that is the reference. It does not have to find out from where you have come. This is an electoral revision of rolls which is under Representation of People's Act 1950. Got nothing to do with Foreigners Act 1946. There is something more substantive. Which is the best document which you have to connect you to your projected parents?
Lordship, in debuter case, Lordship, it is not open for the petitioner, Lordship, to collect the certified copies of voter list, Lordship. So he has tried to substantiate his case to his elder brother, Lordship. And here the next, Lordship, exhibited, Lordship, his father's document of 1966 and 1997, Lordship. Page, Lordship.
1966.
Page, Lordship.
Where is your written statement?
Written
Is it at
statement.
page
Yes,
33?
Lordship. Written statement is at page
33?
33.
Yes. This case is just like a story which I can tell you. A very able student goes to the examination hall, comes out very frustrated, saying that I have the uh, chit, copying chit of what is the difference between A and B. But in the question was, what is the difference between A and B? And therefore I could not write the answer. Here, you got your brother. The brother says that your father has a sister. You say that father has no sister. And then your brother was asked, what is the name of your father's sister? That Pudia was not there. What of his name was not there. So he says, I don't know the name.
For some illiterate person, lordship, it may happen,
Oh,
lordship. to the
illiterate
trap.
person will not know the aunt's name. Very good.
Your lordship may kindly see page 50, lordship.
My brother found something more. Page 26. The voter list does not have the name of your grandmother. Therefore, you could not say the name of the grandmother. And simply, illiterate person, how will you know the name of the grandmother?
Grandfather's name is also, lordship, reflected, so he mentioned.
Page 26, that's what you say. Because in that copying chit, you don't have the name. Obviously, you will not know the name of the grandmother. Sorry, even on merit, you don't have anything. Is there any voter list of your family together, your brothers
Yes, lordship, it is as page
and
50,
sisters?
lordship. It is annexed at page 50, lordship.
50.
Yes, lordship. His family details, lordship. Serial number 708 is, lordship, his brother's,
that's
elder
fine.
brother's name, lordship.
Just now. But he is inconsistent then.
Lordship,
He is inconsistent. Show you why. Come to page 38. This is your written statement.
yes, lordship.
Voter list of 1997.
Lordship.
Now, in this voters list of 1997, the second party's mother's name has been written as so-and-so instead of so-and-so. In the voters list of 97, the second party's mother's age has been written as 58 years, actually the time of so-and-so. In the voter list of 1997, the second party's father's name has been written as so-and-so. Correct.
Lordship.
Now,
Brother's name is Lordship. A. Samad, somewhere
that's okay.
it is A.
That's
Samad,
okay.
Lordship.
No, no,
Abdul.
that's okay. We're not finished yet. Now come to page 35.
Lordship.
The last three lines. Before 97, the second party's mother and all brothers started to stay permanently in the house at the village so and so. And from 1997, the second party and all his brothers stay separately from each other. And then you are showing us voter list of 1997. Now, please come to this opinion. Para 23, as of page 23, opinion. As per the amendment made in the pleading, at paragraph 2, his mother died in the year 1997. Now, if the mother died in the year 1997, when the name is projected, mother ought to have been reflected in the subsequent voter list of. So 97.
Para 23, Lordship.
Pardon me,
Lordship, your Lordship saying that para 23, Lordship.
page 23, paragraph 14, 2 lines.
Yes, Lordship, I have explained in this in my writ petition, Lordship. Lordship, they have submitted enumeration form, Lordship, and their name was not recorded, Lordship. So, Lordship, in this gap times, Lordship, they
See,
could
there's a
not.
big gap in your pleadings and evidence. 97, your brothers were living separately. How the names came in a single voter list of 1997?
The house number is, Lordship, separate, Lordship.
Which page was that?
The Lordship at page 50, Lordship.
60,
50, Lordship.
50.
My elder brother's house number is 284 and my house number is 289, Lordship. Sir, is lordship his uncle lordship. Yes, lordship.
You are leading us to a more difficult situation. It has taken up so much of time to make calculations. When you come to your this self-declaration form at page 46,
At 46 is lordship enumeration form lordship submitted by the
yes,
my brother
Yes.
Mother says here lordship 58.
What?
In the year lordship is
Yeah.
Okay. 59. 59.
That
89, 1989 chalo. Yes, lordship.
48. Other declaration. With the other.
Third lordship.
Very
Is also 58 lordship.
each year.
1994.
Red.
Third lordship is 1994.
And with Abu Samad, A Samad,
Is my brother lordship.
brother, what is his age?
That is written as 40 lordship.
40 or 50?
40 lordship. Yes, lordship.
The age is 30. 97
70.
and 1989, her age is 9 years.
Yes, sir.
Self-declared is 80.
Yes.
Teachers rate.
Otherwise, the brother would have been younger than the mother.
And her lordship is
So self-declaration and then the age of the mother is matched.
in case of age lordship, earlier lordship, every person says it was like that lordship.
No, we don't know.
Even even
don't know.
my
Every
being an
person-
advocate lordship, my age
No, you see,
in
every
different
person,
voter list was
no,
different.
every
lordship.
person would also include myself, my esteemed brother, my secretary. It will include everyone. So generalizing it makes it very difficult. Generalizing it makes it very difficult.
Yes, lordship, but
If
lordship,
you will be specific,
one thing is my respectful submission before your lordship. When lordship, LBL lordship visited the place of in his village lordship, he found that lordship, his name is lordship, in absence of him lordship, his name is lordship Sabed Ali and his father's name is Halem lordship, and his place of birth is even also Morisha Gandhi lordship. So lordship, on that count lordship, the without basing any inquiry or proper inquiry and lordship verification lordship.
this doesn't carry a meaning. We have hundreds of stories to tell you about people. I always tell about one of my friends in the school. nobody knows his actual name. We call him by a nickname. And if you call him by his proper name, nobody will, nobody will identify him. But you call by that nickname. In my school, 90% of our batch will recognize him. There are many people like that. Actual name is not known. They go by the nickname. We studied together for so many years, and I don't know his name. But nickname, if you ask, everybody will know. Six of my classmates are there in this court.
Six voters list and 70 are of his parents. The first time the petitioner's name appears is in 1997. That is 27 years after. There's a gap of 27 years. His continuous stay has not been showed lordship. Continuous stay has to be with lordship that he was in Assam all through. And these two documents, lordship, at page, the voters list of 1997, which is relying on lordship, that is not a certified copy at all. That is, it cannot be treated as an admissible piece of evidence. Sorry, lordship. Page is 50, lordship. 50. Page 49 is 97, page 50, lordship. Lordship, this is an extract of the voters list, lordship. And this cannot be treated as neither a certified copy. This cannot be treated as an admissible piece of evidence. The lordship, shifting has not been explained. 66, 70, there is one village, and 97 is a different village, and there's no explanation to it.
I couldn't catch it. Please repeat again.
Lordship, the voters list of 66 and 70,
Yes.
they are of the parents' lordship, and the petitioner's name appears for the first time in 1997, 27 years. There is no linkage to show the family continued to be in Assam. The continuous stay is not proved and not explained anywhere. Then there is a shifting lordship. 66, 70 is the same village, 97 is a different village. Though that document is not admissible piece of evidence, but shifting has also not been explained at all. There is not a whisper about shifting lordship. And lordship, my friend will read this vernacular part, lordship. There is
No, but,
something.
shifting is there in the written statement.
Yes, sir.
He has, the petitioner has made a statement in
Nijpurva
written
too.
statement.
No, lordship, even if shifting is explained, what about the continuous stay, lordship? 27 years, no voters list. Nothing to show that the family was in Assam, lordship. And that self-declaration form, Lordship, my friend has just explained it. That is Exhibit C and D.
Yes.
That cannot be treated because Lordship will come to page 30, paragraph 35 of at page 23. Relevancy of entry in public record or an electronic record made in performance of duty. An entry in any public or other official book, register or record or an electronic record stating a fact, an issue or relevant fact and made by a public servant in the discharge of his official duty or by any other person in performance of a duty specially enjoined by the law of the country in which such book, register or record is kept is itself a relevant fact. Therefore, in view of the above, the self-declared enumeration form for inclusion of name, the one which is here, role have no evidentiary value, Lordship. That itself has been taken up in the opinion, Lordship. Lordship, he has not been able to establish his linkage with his projected parents. Continuous stay is not there. And the projected parents have also no more voters list to show that they have continued to stay in Assam, Lordship. He's relying on only these 4 documents. The discrepancies in the voters list, Lordship has seen. The mother's age in all the voters list has remained consistent at 58 years.
As well as so and so for the respondent. Sufficient that what is it, so? We'll have to rise. If there are any matters to be,
Lordship has
Listed-
observed the order.
yes,
Yes, Lord.
if you have any matters to be listed out of, please tell the court master.
My lord. Item 45 was there, my lord. Kindly will list on Monday, my lord. That was an emergency.
We can't say because let them take a call.
My lord.
There are many matters.
Item 29,
They are very old and we couldn't, I'm not being able to take it up.
item 29 is a fresh matter, my lord. Can it be taken up on Tuesday?
29.
Read appeal, my lord.
Read appeal.
Read appeal.
Not up Tuesday, Wednesday.
Wednesday, obliged.
Item 44. It's come in admission column.
It's coming in.
Just remind us in the morning,
Mild,
otherwise it loses
mild.
the focus.
Item 44,
Just tell the court master, we don't have time. There's a single bench.
মই চাওঁ হা ঘৰত গৈ যদি আহিব পাৰো আহিম কালি ৰাতিপুৱা আহিম তেতিয়া ঠিক আছে CAB চিন্তা
মই এখন জমি চাই
তেতিয়া ৰাতিপুৱা তেতিয়া কিমান সময় মই 5টাত গুচি যাওঁ 5টা আগতে গুচি যাওঁ মই চাই বলা মই ইফালে আহোঁ মই ইফালে আৰু নাযায়
Football. ঠিক ঠিক 59
Single bench, item 1 for delivery of orders.
is previously dismissed. Itu item 29. 29 no? Item 29 what? Item 29. Kotak. Kotak. Gitu, gitu.